we've got. Hello, everybody. Hello. Welcome. Welcome. Oh, my goodness. What a day it's been. I hadn't planned on going on tonight, but I have just a little bit of time, and I thought I would hop on and say hello. We've had some interesting things going on today in the world, so had to come on and share. How's everybody doing tonight? Hopefully everyone is doing well. Hopefully. Oh my goodness gracious. What a very interesting interesting day we've had here. Oh my goodness. Well, welcome in. Welcome. Good to see you all. Hello. Hello. Yes, so hello. Sick in bed. Oh no, Hitch, I'm sorry to hear that. Love being surprised. Yes, so we've got just a little bonus tonight, everybody. I hadn't originally planned on coming on, but had a little bit of time, was able to come on a little bit later for a little bit here. So I wanted to kind of go over what's going on in the New York civil case. So we've got closing statements tomorrow, everybody. I thought it might be kind of fun to take a look back through the case a little bit. We've spent a lot of time going through everything that's been going on in the New York civil case. So why not come on? It's Wednesday. Exactly, Kristen. Exactly. Oh, exactly. Yes, I know. It's been a lot. It has been. So oh my gosh. Yes. So, Deborah, I wish I could give you an answer, but I don't have an answer. It's madness. Madness, I tell you. Oh my goodness gracious. Well, welcome everybody. Welcome in. Oh my gosh. We've had some crazy business going on for sure. Yes. So, oh my gosh, everybody. So at a minimum, I thought I would take you through the most recent filing out of the New York civil case, everyone, which is just, oh my gosh, just Deborah speaks for us all. Indeed she does. Oh my goodness. So, all right. I usually have the New York docket up anyway because I'm, that's what I do. But there was a filing earlier today, and I did do a brief post on it. So just to kind of update everyone that we had this discussion on whether or not Mr. Trump would be able to do closing arguments now, or part of closing statements. Now, Judge Ingron had said, well, you can, but I've got some rules that you need to follow. So the rules have been set out here in this 10-page chain of emails that I will read to everyone here for tonight. So he kind of set out some parameters, which, that's what judges do. And then Mr. Trump was not amenable to that, so he's not going to be able to, oh my gosh, speak during the closing statements. So yes, the response was crazy. So here's the most recent here at the top, everyone, January 10th at 12:12 p.m. But let's go back in time, everyone. Let me take you back in time to the very beginning of this very interesting exchange here. There's a lot of interesting pieces involved. Oh my goodness. So I thought, let's just revisit this New York case. They are going into closing statements tomorrow and kind of review this back and forth that kind of happened here. Yes, in the beginning, back in the beginning. How can we access all of these? So all of these documents, everyone, these are all available online. You do not have to have any special permission in order to look them up. So what you need is a couple of, hello, John, welcome, thank you. You need to know that this is a civil case This is the name of the case here, People versus Trump. This is the case number. So if you go online and you put in New York civil court documents or something along those lines, it'll take you into the New York electronic filing system. And what you want to do is get to a place where you can put in a number. So you can do an index search, then put in this number, and it will pull up the People versus Trump. And once you click on that, that'll take you into where all the documents can be. Cue the dream sequence. Exactly. So it's all available online. You just need to go into the New York system, and the only thing that, and you can just look around as a guest. You don't have to have any special membership at this point. So yeah, it's all available. The most important thing again is that you have this number. If you have this number, you'll be able to find the documents. So pretty easy once you know where you're looking. It's difficult until you find it, and then it's easy after that. So, but I did want to take you through the history here of the decision that was made regarding Mr. Trump speaking. At closing statements. I don't know, as an attorney, if I had a client that wanted to say something during closing statements, I just don't even know how that would go. I just don't know. But let's start reading through these, everyone. And then I have the New York court file here, so we can kind of flip through there and just go through and have a little memory session before they have their arguments tomorrow. So, oh my goodness. All right, dear counselors. All right, this is the first one here. So we're going in reverse order here. So this is from this person here. Again, I will be a little bit careful with names as we go through this. We've got carbon copies here of multiple attorneys, and we have importance labeled at high level, and it's regarding closing arguments, January 11th. So here's our first email that was sent out. Now, this was Wednesday, January 3rd. Here's the first one. So I'm ready to be entertained during closings. Yes, I am too. So, dear counselors, I write to advise you that we will be back in room 300 on January 11th for closing arguments. However, as the NRA trial will already have started, the courtroom will be set up differently than it was for trial testimony. I've copied Rob on this email, so you may clear any tech questions with him. Additionally, Justice Engeron would like to know how many people and who will be speaking for each side, and how much time each person or each side wants. Please keep in mind we only have the one day. Thank you. And then signed here. So that was the first one, and this was set January 3rd. So we're kind of going back in time here. So let's flip to the next one. So here's the response from a Mr. Wallace here on January 4th. And here is his response regarding closing arguments. So he says, let me just make sure I should be good. There we go. At this time, we anticipate that closing arguments for the AG will take an hour and be conducted by one person from our team, either me or Mr. Amer. That estimate could change depending on the arguments from the defendants and their proposed findings of fact and conclusions of law in their closings. This is also based on an assumption that closing arguments will follow standard practice, with defendants presenting first and plaintiff presenting second. Again, this is, we're not in a criminal case, we're in a civil case, so things are a little bit different. If any of those assumptions are incorrect, or if more time is required, we might divide up the argument. We will let the court know if we think that becomes necessary. We also anticipate that other members of our trial team could address specific questions from the court if they involve areas of their expertise. So here we go. That was one response. And so let's go to the next response that we got here. We have another response back, and this was on the 4th at a little bit later in the day, about 20 minutes later. Dear Mr. Wallace, thank you for your response. The court is currently operating under the assumption that we will follow the normal practice of defendants going first and plaintiff going last. We will, however, wait to hear back from the defendants. So we have that response. So let's see next what response we have. We have, oh my goodness. It gets better, everybody. At each letter, it gets better. It just really builds on itself. So we've got January 4th, about an hour later. And we have a response to the original email from Mr. Trump's attorney. At this time, the defense anticipates that closing arguments will take approximately 2 hours, 2 hours, 15 minutes total. I will present the more extensive argument, and then Ms. Haba and Mr. Robert will also present more limited arguments. Additionally, President Trump plans to present argument at closing as well. Okay, here it is. That's the moment. But we anticipate all such arguments will be completed within the above time estimate. And it continues to the next page. As a practical matter, this means the defense will be done before the lunch break, leaving ample time for the Attorney General the remainder of the day. Please advise if you have any further questions. Thank you, Chris Keyes. Right, what? I know, exactly. All right, so that was his response. So he's now said, oh my goodness. So here's our response from the first one. Right. So this all started by the court sending out a letter saying, hey, let's talk about closing statements. And then the AG was like, okay, we're going to need this much time. And then defense counsel's like, well, we're going to need this much time. And Mr. Trump is going to want to be making some statements too. So let's see. Yikes. Let's see how that gets responded to. So this is January 4th at 12:47 p.m. So the next response is from Mr. Amer, January 4th at 5:13 p.m. And it's a bit lengthy, so we'll take a minute. This is special counsel again out of the AG's office. So this is their response to defense counsel. Oh my goodness. All right, so here we go. Justice Ingron, this person and this person. Plaintiff opposes defendant's plan to have Mr. Trump present present any portion of their closing argument. Mr. Trump is certainly not permitted to do so as of right. Under the CPLR, if a party appears by attorney, such party may not act in person in the action except by consent of the court, citing 321 sub A. Even in a criminal proceedings where the Sixth Amendment and the state constitution afford a defendant the right to counsel or to self-representation, they do not guarantee a right to both, citing Rodriguez here. These are separate rights depicted on the opposite sides of the same constitutional coin. To choose one obviously means to forego the other. Quoting Purnett, there is no right to hybrid representation in which a defendant is represented by counsel from time to time, but may slip into pro se mode for selected presentations. Oh, it's so ridiculous, everybody. It's just so ridiculous. Oh, my goodness gracious. All right. And we're citing the Perez case, also the Riveniter case. By accepting counseled representation, a defendant assigns control of much of the case to the lawyer, who, by reason of training and experience, is entrusted with sifting out weak arguments, charting strategy, and making day-to-day decisions over the course of the proceedings, and then citing Rodriguez again. Accordingly, a defendant who chooses to defend through counsel in criminal or civil actions cannot, as of right, present closing arguments, citing Richardson, which is a 1958 case. Oh my goodness. Nevertheless, the court has the power, in the exercise of its discretion, to grant a specific application for limited participation of a defendant as counsel, but only when doing so will not unduly disrupt the orderly administration of, can we guess what the word is? Justice, right. Or unfairly prejudice the prosecution's interest. Citing Richardson again and the Powell case here. Allowing Mr. Trump to present even a portion of the defendant's closing argument would do both. The court has already found that Mr. Trump is prone to giving irrelevant speeches, lacks self-control, is evasive in responding to questions, and then we're citing to the transcript. He's citing where that has occurred. And has repeatedly violated court orders which he has been sanctioned. Allowing Mr. Trump to present closing argument will invite more speeches that will unduly disrupt the proceedings, citing Richardson again. Moreover, Mr. Trump had the right to present testimony on defendant's affirmative case, but elected at the last minute not to do so, explaining in a subsequent social media post that he already testified to everything and has nothing more to say. Allowing Mr. Trump to participate in closing arguments would effectively grant him an opportunity to testify without being subject to cross-examination. That is so true. Thereby depriving the people of a fundamental right to their significant prejudice, especially in light of the court's prior determination that Mr. Trump was not a credible witness. And then we're citing a specific document here. Oh my gosh. Citing Barnes as well. By avoiding his obligation to testify at trial, in which he was seeking millions of dollars, plaintiff was able to frustrate the city's fundamental common law right to cross-examine a witness. Mr. Kaiser's email should be treated as an application to allow Mr. Trump to present closing arguments, and for the reasons above should be denied. Respectfully submitted, Special Counsel. Oh my goodness gracious, everybody. Sometimes I feel like, oh, it couldn't possibly get more ridiculous, and then it does, and then it gets more ridiculous. All right, so that was on the 4th, and that was at 5:13 p.m. So let's see what the response is. Oh my goodness. This is from the judge. So here's the judge. Didn't help the defendant to speak on their... Oh, no. I've typically no, especially if you don't understand the nuances. Although really in this case, because there's not a jury, I mean, they're kind of... I can see there's different rules that the judge may look at, but... yeah, you can't... Closing arguments aren't testimony. They're not evidence. They're persuasive arguments. It's something you're presenting to the judge and to kind of close everything up. So it's not evidence. And so whatever you say in your closing arguments, I mean, it has to be appropriate as far as ethically goes. But if you don't have legal ethics, first of all, that's a question to be asked constantly. But I mean, Mr. Trump isn't an attorney. He doesn't have any kind of legal ethics he has to follow. So for any kind of format for a closing statement, it's just crazy. That's madness. It's complete madness, everybody. All right. So I'll grab my tea here for a minute, and then we'll get into Judge Inkron's response. Oh, my gosh. Okay, so the next day, on January 5th at 1:18 p.m., Judge Engeron sent out a response to everyone. Does he have any ethics? That's an excellent question. Dear counselors, in the email to which this email responds, Mr. Kaiser announced the defendant, Donald J. Trump, plans to present argument at closing pursuant to CPLR 321. I'm sorry, I can't stop laughing, everybody. I apologize. This is ridiculous. If a party appears by attorneys, such party may not act in person in the action except by consent of the court. Mr. Trump obviously appears by attorney. Thus, and as far as my research has revealed, whether he may present a closing argument is completely at my discretion. That's correct, Judge. You are correct, sir. And he goes on, particularly in a non-jury trial, I'm inclined to let everyone have his or her say. Moreover, the more reasoned analysis I receive, the better I will be able to decide the case correctly. Furthermore, Mr. Trump is the person with, by far, the most at stake in this enforcement action. Thus, in my sole discretion, I will consent to let Mr. Trump make a closing argument if and only if, through counsel by January 9th and by himself personally on the record, just before he speaks, he agrees to limit his subjects to what is permissible in a counsel's closing argument. That is, commentary on the relevant material facts that are in evidence and application of the relevant law to those facts. He may not seek to introduce new evidence. He may not testify. He may not comment on irrelevant matters. In particular, and without limitation, he may not deliver a campaign speech, and he may not impugn myself, my staff, plaintiff staff, or the New York State court system. None of which is relevant to this case, and all of which, except commenting on my staff, can be done and is being done in other forums. If Mr. Trump violates any of these rules, I will not hesitate to cut him off in mid-sentence and admonish him. Yikes. If he continues to violate the rules, I will end his closing argument and prevent him from making any further statements in the courtroom. If he violates the current gag order against him, I will immediately direct court officers to remove him from the courtroom forthwith, not forthwith, and will fine him not less than $50,000. Oh, yikes. Finally, he must state on the record before he begins to speak that he also understands that without exception, defendants collectively have only from 10:15 to 12:45 with one 15-minute break to present their arguments, meaning that whatever time he speaks is time that other defense attorneys will not have. Oh my goodness. Plaintiff will also have 2 hours and 15 minutes from 2:15 to 4:30 to present closing arguments. Mr. Kais, please respond. Signed, Justice Engeron. Oh my goodness. All right, so that was Judge Engeron's response to that. Like, okay, well, sure. Let's try something new and different. Why not? Oh my goodness gracious. All right, everyone. So let's see what response we got here. Let's see how we responded. Oh my gosh. I can't handle 2024 either. I know. I'm sorry, everyone. I have to wipe the tears off of my face. I can't. How is this happening? One moment, please. Okay, here we go. Let's get serious again. All right, so here's our next response, everyone. So this is Tuesday, January 9th at 11:10 a.m. So let's just go back in time for a moment. This was January 5th, all right, at 1:18 p.m. So this is 4 days later here. So he's sending, this is defense counsel's response to everyone. Justice Engeron, thank you for your response and proposal below. First, I agree in a non-jury trial, and especially this trial, your inclination to let everyone have his or her say is the best approach. And especially this trial, your inclination to let everyone have his or her say is the best approach. Also agree that the more reasoned analysis you receive, the better you will be able to decide the case correctly. Additionally, and as you note, President Trump has by far the most at stake in this enforcement action. Therefore, allowing him to make a statement is not only the best course of action, it is the fair and correct approach. I'm glad that the counselor could tell the judge the correct approach. Oh my goodness. Oh my gosh. However, he cannot agree, nor would I recommend he do so, to the proposed preconditions of prior restraints. Uh-oh, everybody. Oh no. Gloves are coming off. No. Oh my goodness gracious. All right, so we're flipping here, everyone. Let's flip. Here we go. As an initial matter, under the present circumstances where the AG seeks the unconscionable and draconian penalty of prohibiting President Trump, who has contributed both professionally and personally to the economic development, job growth, and real estate footprint of New York for some 50 years, from ever again engaging in any lawful business activity in New York, even though the evidence at trial established he did nothing wrong. What? Oh my gosh. Given same, he most assuredly should be accorded an opportunity to address the court. Now I'm wondering whose idea it was that he participated. Oh my goodness gracious. Further, the preconditions and prior restraints you propose are fraught with ambiguities, creating the substantial likelihood for misinterpretation or unintended violation. For example, the notion he could not comment on AG, the plaintiff, is simply untenable. Moreover, given the history of these proceedings, agreement to such ambiguous limitations will no doubt simply create further disagreements. Therefore, while, as noted, I agree with your stated conclusions that the fair and best approach is to allow President Trump to make a statement, he cannot agree to the proposed limitations and prior restraints. The existing gag... I'm sorry, everybody. I'm pausing for a moment. We're in court, right? This is a court proceeding. Let's just remember that for a minute. Pause. This is court. There are rules. Okay, unpause. The existing gag order, although on appeal, remains, but there should otherwise not be further prior restraints on any statement he provides at closing. What? This is ridiculous. This attorney out there, if he was in front of me, I would say, dude, you're not as special as you think you are. Please advise as to whether you will permit President Trump to speak at closing without the proposed limitations. Thank you respectfully. All right. So thanks, Chris. Thanks for that. So here we go. That takes us. Oh my gosh. Let's make sure I'm in the right frames here. Give me 1 second. All right, so we had this here, and that flipped over. So we've got January 9th and then January 10th. Hold on, everybody. January 10th, January 9th at 9:26 p.m. All right, so just 1 second. So here's where we just finished here, and then we have... previously, again, we're going backwards in time, everyone, so I'm struggling with my math, so just a minute here. Number 2, this takes us then to Judge Engeron's response, and it looks like that goes to this page here, just a minute. Wait, I feel like I've missed something. Okay, I've got January 9th, everyone. Hold on. I've got January 5th, January 9th, and then we're bumping up to Judge Engeron's response. I've got, oh, here we go. All right, sorry, everyone. I had a moment. Technical problems. Okay, so, and we're back to the page that was there before. Yeah, page 1. See, I've got 2 page 1s. See? Yeah, I know. It's, I have to justify myself. All right, so Judge Engeron, this is his response. All right, so here we go. This is January 9th at 1:23 p.m. Dear Mr. Keiss, now we're flipping back to page 2 again. Oh, my goodness gracious. Back to page 2. You're and your clients, so hold on here, everybody. I'm going to get mixed up again. Your and your client's rejection of the reasonable normal limits I am imposing on any argument by Mr. Trump, which are the same limits that the law imposes on any person making a closing statement, completely justifies the need to impose them. Closing arguments are for an advocate to comment on the evidence presented on the relevant law and on how the latter applies to the former to justify the results sought. Such arguments may not be used to testify, to introduce new evidence, to make a campaign speech, or to comment on irrelevant matters. Citing the Kennedy case, the trial court may preclude summation arguments that are speculative and unsupported by any evidence. Citing Ramirez, summation is not an unbridled debate in which the restraints imposed at trial are cast aside so that counsel may employ all the rhetorical devices at his or her command. Citing Hightower, counsel must, among other things, stay within the four corners of the evidence and avoid irrelevant and inflammatory comments. To the left, yes, everybody. All right, 1 minute. Oh my gosh, one moment. My light went out. Okay, sorry about that. Always the highest of quality here for everyone. Oh my goodness gracious. All right, here we go. Let's try this one again. There, woohoo! We've got light again. All right, now let's get centered again. Got to get back into this here. My training, I got to rely on my training here. I was not trained properly at law school. Okay. Why does Chris never use capital letters? That's a great question. I think that's an excellent question. I'm not sure. Okay. All right. We're perfect. Just making sure. I just want to make sure that my camera is in frame, everybody. So just bear with me for 1 more minute. Sorry. There we go. All right. Hopefully that should be good enough. At least you use capital letters. Oh my gosh. All right. So we have a light. We're back. He was citing the Hightower case. Again, counsel must, among other things, stay within the four corners of the evidence and avoid irrelevant and inflammatory comments, which is very true. Anyone can comment on the arguments of an opposing party or counsel, but may not seek to impugn their character. Of course, I will apply common sense if there's any issue or doubt. I will not let anyone violate the normal rules of courtroom procedure that govern closing arguments. The limitations I'm imposing in my absolute discretion are not subject to further debate. Ooh, he's put his foot down. Take it or leave it. Please let me know which by 4 p.m. today. Oh my gosh. Oh my gosh. Okay. So, all right. Let's go back. So we have, again, page 2 here. And this was 3, so this is 2 with Judge Engeron starting here. Here we go. So I think, oops, that's January 10th. Sorry, everybody. Seriously, these pages are just a little different. All right, here's that. And that goes to page 2. So then we bump up here. All right, so now Mr. Kais's response. First, we've got Judge Engeron, and then he does make one more comment here. So that previous comment was done at, what time was it? Let's look real quick. I'm seriously, everybody, I don't know why I'm struggling so much tonight, but so his comments, and now Judge Engeron did one more issue, and he said, Dear Mr. Kais, not having heard from you or any of the other defendant attorneys by the 4 p.m. deadline pursuant to CPLR 321 for the reasons stated below, Mr. Trump may not speak in court on this Thursday, January 11th. In order to preserve the record for appellate review, I will docket this email chain as well. So this is January 9th at 4:16 p.m. His previous one was 1:23. So apparently he did not hear back. And then Mr. Kais responded, Justice Engeron, apologies, as I did not see your deadline. Additionally, my client is in the air, so I have not yet been able to discuss your email with him. Would therefore request you allow until tomorrow morning for any response. All right, so now oh my gosh, he's in the air, everybody. All right, we're going to be careful here. So we have this here, and then just making sure we've got 4:18 p.m. And then the next one is on January 9th, so just a few hours later at 9:26. So this is his response. Again, I'm making sure I'm in frame here, everyone. So, Justice Ingron, I'm sad to advise the court that Mrs. Trump's mother passed away this evening because of the challenges presented by this deeply personal family matter. Oh, that's not, oh my goodness. President Trump has asked that I request the court to postpone the date for closing argument until on or after January 29th, so he may attend and participate in the court proceedings respectfully. Okay. So then Judge Ingron is responding back. I'm trying to make sure I keep all of my pages in alignment here. So the next response is at 8:48 a.m. by Judge Ingron here. Mr. Kais, I'm sorry to hear the sad news. The request to postpone tomorrow's closing argument is denied. I'm sure you realize, although you may not realize to what extent that every appearance of Mr. Trump requires court officers, court clerks, administrators, security details, technical people, etc. to rearrange their schedules and to plan for the day. The administration even had to evict the jury trial currently taking place in room 300 for tomorrow. Of course, I'm anxious to hear a full day of closing statements as I consider the case as a whole. On balance, going forward makes the most sense. Please tell Mr. Trump that I am sorry. I still hope and expect to hear from you by 11 a.m. this morning as to whether all this is even an issue. Signed, Judge Ingron. All right, so we're getting... Yikes, now we're getting into the final stages, everyone. All right, so that was at 8:48 a.m. And then we have another response here by Mr. Kais at 10:51, so 2 hours later. Justice Ingron, oh, there's capitals here. Despite the fact that his mother-in-law, who he was very close to, passed away late last night, President Trump will be speaking tomorrow. Respectfully, Chris. Okay, so that was his response. Now, oh my gosh, we've got 10:57 a.m. So 6 minutes later, everyone, Judge Ingron is back, and he's saying, Dear Mr. Kais, as I have already indicated to you, if Mr. Trump wishes to speak pursuant to CPLR 321, you will have to tell me now that he will agree to the limitations I have imposed, which go without saying and apply to everyone, and he will have to agree to do so tomorrow on the record, which should take no more than a minute or two. So that was his response. So there's the judge. And then now we're on the very final page, everyone. Somehow we've made it to the end. And we've got another response then. Let's just make sure I'm in the right spot. So 10:57 a.m. And now we have 11:40 a.m. So Mr. Kais responds back in about an hour. Judge Ingron, this is very unfair, Your Honor. You're not allowing President Trump, who has been wrongfully demeaned and belittled by an out-of-control, politically motivated attorney general, to speak about the things that must be spoken about. Goodness gracious. Oh my goodness gracious. And then that's it. There's no more. There's no more to that. So then we have 10:54. So 15 minutes later, everybody, we have, oh my gosh, Dear Mr. Kais, I won't debate this yet again. Take it or leave it, now or never. You have until noon, 7 minutes from now. I will not grant any further extensions. All right, so there we go. And then we're up at 12:12 p.m. Again, I'm just making sure that I'm in frame here, everyone. All right, and here's our last one from Justice Ingron. Dear Mr. Kais, not having heard from you by the third extended deadline, noon today, I assume that Mr. Trump will not agree to the reasonable lawful limits I have imposed as a precondition to giving a closing statement above and beyond those given by his attorneys, and that therefore he will not be speaking in court tomorrow. As I previously indicated, this email chain will be docketed in the New York electronic filing system to preserve your appellate rights. Justice Anger on. Oh my goodness. Oh my goodness. Yes, he did. So that's what we have there. A literal definition of a hissy fit. Yes. Well, yeah. I mean, it's, don't get me wrong. I absolutely, anytime there is a loss, it is difficult. True. That is very true and very unfortunate. But it sounds like the judge had some good points too. So, right? He said, stay down. He was so patient considering they tried to sneak. Oh, I know. So again, we had this just random tossing in of an email like, oh yeah, and Mr. Trump would like to speak too. And then it was like, okay, well, sure, why not? Why not give him a chance? But there are rules because we're in a court of law. And then his attorney's like, I don't care about that. We'll say what we want to say. Meanwhile, the AG's office is probably just like, ping pong back and forth. What just happened? Oh my goodness. So this is something, you don't usually hear from an attorney. This is very unfair, Your Honor. Like, what? So it's worth coming online for. Oh, thanks, Hitch. Will you be going over the DC Circuit immunity opinion whenever it drops? Absolutely, Jared. Absolutely, I will be. For sure. Absolutely. Yeah, James was correct. Then would be test. Yeah, exactly. And, a lot of people may not realize that, but of course, opening and closing statements aren't evidence. They are not testimony. They are persuasive arguments that we make to the judge or to the jury. And so we have different rules of evidence that apply and different protocols that we use for opening and closing statements because they're not evidence. Now, if they were evidence, we would have to use different rules of evidence, and that involves being cross-examined. That's part of evidence. So if it's not evidence, we don't have to use those rules. But if it is, then we do. And a closing statement is not evidence. When someone's insane but predictable at the same time? That's a great question. I'm going to need to think on that. That's a thinker. I'm going to have to figure that one out. Telling the judge that they're unfair usually results in worse outcomes for my clients. Oh my goodness. I can't even imagine saying to a judge, well, you're being unfair. Like, what? Are you? Oh my gosh. Like, that law school education's expensive. You can't come with something better than that. He should have testified and his own lawyers could have questioned him. Well, exactly. He had that right. He absolutely has the right to testify or not to testify. That's absolutely within the purview of his rights. So it seems to me like if he had further things he wanted to say, he could have testified or presented it in another way that was according to the rules of evidence. But that's not really happening here. That's not fair. I know, everybody. Life isn't fair. Go to your room. Oh my goodness. Oh my gosh, everybody. Yeah, I mean, I chuckle here because I think there comes a point where we're really getting into the land of absolute ridiculousness here. We're really getting into that place. This is ridiculous. So, my moderators are amazing. Yes, they most certainly are. I'm very thankful to them every day, every single day. So, again, I think Judge Angron here was like, hey, let's give it a go, but we have to have some rules. And that seems to be one of the things Mr. Trump is not a big fan of. He's not a big fan of rules. And, that's fine. He doesn't have to be a big fan of rules. But when you're in court, you got to follow the rules. If your judge wants you to stand, you stand. If he wants you to sit, you sit. If your judge doesn't want you to go in a certain direction, then you stay away from there. Passing didn't stop him from tipping on the... yeah, I agree. It really didn't, Deborah. You wouldn't be able to tell, would you? So again, and with I mean, that's a sad moment, and I'm sorry for the loss. That's a very sad situation. And unfortunate, and we all want to have to be able to pause things, but the wheels of justice keep spinning, people. They stop for no person, dead or alive. They stop for no one. They just keep going. So he makes a good point. He's like, look, we've got this court for like 6 hours. That's a total amount of time, essentially. He's giving 2 hours to defense and 2 hours to the plaintiff, and, you know, with some breaks involved in there. But so it's a short period of time. They've put a jury trial on pause. They have to get everything set up to allow for security, proper security measures, and rightfully so. They should do that. That's what's proper. But, you know, he's right. Like, I'm not sure how we're supposed to move this around. And again, we're here for closing statements. We're not presenting new testimony. There's no new evidence. This is just a persuasive argument put on by the attorneys at the end of the case. Was earlier in the case. Yeah, if it was earlier in the case, yeah, I agree. I think that's a good way of putting it too. And if it was something other than closing arguments. I mean, again, closing arguments is something you can call in, honestly. And, you know, you don't want to. If it's your case and whoever's your strongest arguers who you want to do your opening and then come back with your closing. But there's a lot of things going on. We don't have a jury here, so you don't have to have that introduction and, you know, close the same way you would with a jury, because we're dealing with a bench trial, first of all. And second of all, you know, you can, all of the briefs, all of the issues, everything has been briefed and argued, everything. So this is just kind of like that period at the end of a sentence, but you still have all the sentences up to this point already. Important information that may not be covered by the media. Well, yeah, and, you know, I think what's interesting to me is probably not that interesting to most of the media, which is fine, because I'm kind of a dork. But I'm happy to share. I mean, I had to go through these emails, everybody. It's just one of those moments of like, oh my gosh, if I tried to pull this with one of my local judges, oh my goodness, I would be lucky if I was able to go home for dinner. I would have had some problems. Oh my gosh, I would have had some problems. At a tournament, delays. Oh, I know. Dork Squad Unite. Absolutely. Absolutely. So this case has been quite the case, everybody. It really has been. And, you know, this is, again, kind of that last piece to it. But just as a friendly reminder, I mean, we've been going through this case page by page, document by document, as it has all come about. So I was just going through and reviewing, you know, the different depositions that we've gone through, the different orders, the motion for summary judgment. I mean, we've invested a lot of our time. Again, I have the AG's opening statements in here. I did a full live going through that. We went through lots of different testimony. Yikes, we went through that guy's testimony. So, you know, we've spent quite a bit of time on this case. I feel like this is kind of, you know, a case that we're waiting on too. We're waiting for the final verdict to come in as well. And we put the time in to try to figure out all the different kinds of motions. We've all figured out this financial statement situation. We're all making sure we take notes so we write our financial statements out correctly. We've just spent a lot of time with it. So, why didn't this one have to wait for the immunity issue to be resolved? It just wasn't raised in the proper place for it. Now, the E. Jean Carroll case, I'm putting that one together. There's two of those. The easiest way to think about the E. Jean Carroll cases, everyone, is that E. Jean Carroll 1 has to do with June statements. Carroll 2 has to do with October statements. That's the easiest way to remember those two cases. But he had put in immunity in that one as well, and it had gotten appealed, and they had rejected that immunity. So the immunity has been put around, but you still have to plead everything at the right time in the right manner, or you're not going to be able to do it. I mean, we have a lot of rules, so we got to kind of follow those rules. He committed crimes before POTUS. Right. And although there's a lot to this, because we had questions about the subpoenas used in order to get some of the documents that have been involved here. So there's a lot of questions that have been up for grabs. We're invested in the outcome. Absolutely. With the limitations expired, also banks saying there's no fraud. So I don't I guess I don't ever put my belief in a bank when it comes to the law. I mean, no offense to banks, everybody, but the law is up to the people that enforce the law and make the laws, right? I mean, that's the system. A bank is, just a bank. So, no offense again to banks, but whether it bothered them or didn't bother them is really, not my problem. The only problem is if there's a law that was legally passed, put on the books, and that law was violated. That's where the questions come in. You can't bank on a bank. That's so funny. And I get it. I mean, sometimes banks are like, oh, it's no big deal. Who cares? Let's let this slide. I'm like, that's fine. But it's not the bank bringing the criminal action or the lawsuit. It's the harmed party. And the harmed party is society. It is the people that wrote the laws. So that's the harmed party. And so they have every right to have their laws enforced. New York passed a law, and New York is like, you know what? You broke the law, so we're going to come for you. That's how that kind of works. Got a lower rate. Yeah, I mean, again, there's also victims not necessary for prosecution. It most certainly is not. And you certainly do not have to have a victim, of course. But I mean, here, there was a law that was written, and whomever wrote that law, whoever that law was intended for, was harmed when it was broken. So if you feel like you need a victim in order to be able to go forward, you can kind of shape it that way. But no, I mean, if you're on an abandoned road, right, and you're speeding and you get a speed ticket from a camera, is that okay? I mean, who's the victim? Nobody was there. No cars were there. It just happened to trigger a speed camera. Should you not have to deal with that kind of situation? Should you not have to follow the speed limit? Those kinds of questions it's the same thing. Like maybe the bank was like, whatever, we don't care. We got bigger fish to fry, or whatever. Whatever, however they want to put it, and that's fine, but it's not up to them. It's up to the person, the people that voted for the people that wrote the laws. Hiding it does. Yeah, this has taken a long time, everybody, and there's been a lot of up and downs in this entire case. There have been a lot of appeals. There's been a request for recusal. There's been a lot of media. We had the gag order that was appealed up and down again. And of course, we have that original motion for summary judgment that was granted in part by this order all the way back in September 26th. So this was the order that kind of set everything into play, where already there was a finding of wrongdoing. We just had a couple more counts where we needed to assess the level of mens rea, or the level of intent that was involved. But I mean, it feels like it's been 5 years, but it's only been since September that we've been going forward on this particular case. But yeah, I mean, it's got everything. It's got, Ivanka was able to plead out. She was able to get herself out of this case, and Eric was explaining to us how to pour concrete, and Don Jr. was able to flirt with all of the other attorneys and depot people. Like, good for him, Meanwhile, he's had his own people serving time in prison who've come back in. I mean, it's like, what? This is a full meal of a show, everybody. It's a full case. It is exhausting, Kim. It is. You have to pace yourself. You have to pace yourself. You can't sprint it. You have to take breaks, stay hydrated, eat bananas. Don or Don Jr. Yeah, Don Jr. Well, yeah, I guess Don did too. Or Mr. Trump did as well. We had some very interesting pieces of his depositions that were made. I mean, there's a lot of information that came out in all of this. And we were able to figure out, like how many billions he had overestimated his value at. So very interesting, very interesting. End up with charges against them. So I think that's a good point, everybody. I think typically when we call attorneys out, it tends to be when the case is finishing, towards the very end of the case or when the case is finished. That's when it's time to go back and clean up the mess that you have seen. So if attorneys are going to be charged or are going to be sanctioned or are going to be brought up on ethics questions, all of those things will start to come in once the case finishes, unless those same attorneys are still active on other cases. That's the only thing that could kind of put a roadblock in the way. And that's because you want everyone to have due process. You don't want to pull somebody's attorney out in the middle of the case and be like, you guys are awful. I mean, although it does happen, and it has happened to his attorneys, and they were sanctioned like $7,500 and $1 million in Florida. I mean, there's been a lot of sanctions, more sanctions than I've seen in one case, I think, in a while. But as far as further sanction goes, I don't know. At this point, Judge Angron's probably like, oh my gosh, can you get this off my desk? Can you please? I beg you, can we be done with this case so we can move on? Oh my gosh. Looking for a new wife. Maybe. Maybe. I don't know the personal life of the world of that person. So I try to stay out of that. And the further I read into the E. Jean Carroll cases, the less I want to know. Like, oh my gosh, my goodness, everybody, my goodness. The details of those cases, the fact that this is even something that has moved to this point where he could be a Republican nominee with the kind of findings that have been found in those cases is just mind-blowing. It blows my mind. I understand people are frustrated with him for multiple reasons, but if anyone just sits down and reads through those E. Jean Carroll cases and you come out the other side and you're like, oh my gosh, what has happened? How can this be? How can this be okay for so many? I just don't, I can't. I have a hard time accepting it. It's very difficult. So those will be a couple of tough lives coming up in the future, everybody, that I will be going through. Do you think he will have more defamation suits from E. Jean Carroll? He keeps tweeting about her. It's absolutely possible. So it's interesting because after Carroll 1, it took about 2 years before Carroll 2 happened. So there was like this kind of break in between. But once he's ramped it up again, it also has to do with how exhausted Miss Carroll is. I mean, quite frankly, this is exhausting. This has been going on forever. Since 2019, since, the writing of her book where she started in 2017. So this is exhausting. And she's the one who was so harmed in the situation. And she's the one, having to go forward on it to keep it going. So this kind of strategy of stalling and delaying and stretching things out as far as they possibly could go, this strategy absolutely works when you finally wear down a plaintiff into a point where they're like, I'm just done with it. I'm just done. I'm exhausted. I just want it to be over. Miss Carroll has a strength I don't know that I've ever seen before to continue on in these cases the way that she has. She's just gone after it like a crocodile. I'm just incredibly impressed with that. Look into how her, I don't know. I think it's always hard when we lose someone. So could you move the numbers up? Move the numbers up. Like up here, Deborah, is that better? My eyes. No, my eyes. I know, it's so hard with all these numbers to get them all here on the screen properly. There we go. There we go. Yeah, she hadn't been well for a while. I mean, it's sad. I feel sadness for that. I think it's always hard when you lose a matriarch. So I think that's very difficult. It's hard to see the comments. Oh, right. I think even if I move it up a little bit more, the comments might be a little bit easier. Is blurring the chat. Oh, I got you now, Deborah. Thank you. I'm so glad you all tell me these things because I just I can't tell myself. So I really appreciate it. I rely on your expertise. So very helpful. Thank you very much. I appreciate that. I think Navy was saying something earlier about that and I had forgotten it. So sorry about that. Yeah, blurred vision. I know. Much better. Oh, thank you. I'm so glad. Yep. Fantastic. It's very sad for anyone. Absolutely. It really is. I agree. I agree. And it really is unfortunate. It's a, it is sad when that happens. But, there's, again, the wheels of justice keep turning. So planning to read more today, or was that the main thing? So that's pretty much it for tonight for my readings, everyone. I had just wanted to take you through those emails, let you know what the final word was on that closing statements for tomorrow, and just kind of do a friendly reminder of how much this case had involved. And we've been hanging out and going through all of these different documents for months now. So we, I think, are all ready for closing statements tomorrow. I think we're ready. So everybody wear your best suit and tie. He's been different. Yes. He has been. He has been doing. Thanks for the surprise. Oh, absolutely. Absolutely. So make sure, everyone, you get lots of sleep tonight. You get up in the morning, get your cup of coffee, get your dressed in your very best. We won't be able to actually be there, but it will be very exciting. Very exciting, I think. Did you see comments Nancy made today in chamber? I've not. I kind of walked away. I had to walk away from Congress today. Congress was getting to be a bit too much. It was closing statements televised. I don't believe so. No. I think there will be real-time reporting, though. I think there will be people in the courtroom that will be posting what's being said, but I don't think we will have actual recording going on. I know. It's a bummer. I'm bummed out, too. Cheap prison labor. Oh, my gosh. Ew. Is prison labor really cheap, though? I mean, ultimately, whoa, that took an unexpected turn. That's crazy. We go live after. I will be going live tomorrow at my normal time, but I will probably be also doing a couple of bonus lives. There's just so much going on, everybody. So I will definitely be on sometime during the day, and then for sure it's 7 o'clock Central tomorrow for sure. I had to step away. Oh, no problem. I am doing a bit better about getting things posted up on my Tube of Views, so this should be up as well. What's a 7th Amendment trial? A jury trial at the federal level with a certain amount of money involved? Is that what you're asking? Because the 7th Amendment doesn't apply to the states, right? So it couldn't be a state action. It'd have to be a federal action. Thank you so much. Oh, absolutely. You're awesome. Oh, thanks, Troy. Thanks. Yeah, I've read the Constitution a few times. I do enjoy it. It's fun. It's a fun read. Yes, well, thanks, Suze, for coming. Thank you. I thought you were taking the day off. I did. I took most of the day off, but I had to come back on. I had just a little bit of time tonight. I was able to come back on and kind of go through this idea of Mr. Trump and his closing statements and the unfairness. Oh, I'm so glad to hear that, Anthony. But his emails. Oh, I know, the emails. But you're being unfair, Judge. Like, what are you talking about? Oh, my goodness. Thank you. Oh, absolutely. Always good to see you, Justice O'Connor. Always. So with that, I know, not the emails, everyone. I know. Oh, my God. Oh, thank you for the roses. That's so sweet. So I will be back, everyone. Just as a friendly reminder, let me show you the calendar that we've got. We have the closing statement set for tomorrow. I will definitely be on at some point tomorrow during the day. I'm not sure exactly what's going to work in my schedule, but I'll be back at 7 o'clock Central Time as per usual. And then we are hopping right into, now I believe the 15th. Isn't the 15th Martin Luther King Jr. Day? Is that right? I think that's actually a holiday. So we've got the trial actually starting, the jury trial piece of it starting on the 16th. Yes, it is. Okay, thank you, Anthony. Okay, thank you. Yeah, I was wondering. I thought so. Okay. So we have the Iowa caucuses, though, are set. So that's kind of a big deal. I saw that Legal Dad had some concerns about the weather in Iowa, so yikes. I would agree with that. Hopefully everyone is able to get around and do what they need to do. So we have the caucuses there, and then we do have the Carol 1 or the June comments jury trial element for damages that is done on the 16th. So I will be posting and going through more details on the Carroll cases to update everybody before they actually start pulling in jurors, so we can have all of that in our back pocket when we go forward and go through all of the information. So it has been quite a road with this particular case, everybody, but I will go ahead and call it for tonight. And my high-speed printer, oh my gosh, everybody, I tell you, I couldn't do this without all of my amazing supporters out there to pay for toner. Oh my goodness. Oh, the toner, everybody. My local office supply store, I bring in the toners, I get the toners, and they know me by name now. It's fun. Yes, thank you. Thank you, everyone, for coming. So have a wonderful night, everyone. I wish you all the very best. Thanks for swinging by for kind of this little bonus live tonight. I will be back again tomorrow. And of course, if anyone's got questions, feel free to leave them on any of my posts. I will do my best to get back to you. So, oh, thank you. Thank you. Look at that. All I see is like toner ink when I see gifts like that. I'm like, oh, look at that. I've got toner for another month. Woohoo. But have a wonderful night, everybody. Oh, thank you. Have a wonderful, fantastic night. It's so good to see you. Oh, look at all of that. Look at all the toner. Oh, my gosh. Oh my gosh, you're all amazing. So thank you for your time and support, everyone. I will be back again tomorrow. Take care, everyone, and have a wonderful, wonderful night. Always fantastic to see you all. So take care.